Imagine this. You're in the middle of a lawsuit. A judge is circling like a hawk. Opposing counsel is hungry for your bank account, and your hard-earned wealth is staring down the barrel of legal seizure. But then you pull a trigger, and instantly your assets disappear from reach. They're gone. They're protected. And today I'm going to show you exactly how to make that happen legally, powerfully, and in a way that most lawyers don't even understand until it's too late. Hi, I'm the business guy, the CEO of the Lawyers Limited Law Firm and Asset Protection Planners. I've been in the asset protection field for 34 years and have personally helped thousands of high net worth clients shield their assets from lawsuits, divorce, and financial predators. In fact, we've set up more Cook Islands trusts than anyone in the world. But what I'm going to share today might be the single most flexible and powerful tool in our arsenal, the trigger trust. It's the perfect marriage between two strategies, domestic and offshore trusts. You get the control and convenience of a U.S. trust, but the nuclear lawsuit deterrent of a foreign asset protection trust ready to activate when you need it. Now, you might be wondering, if this is so powerful, how is it even legal? We'll get there, but first, we'll walk through how it works. A trigger trust, which by the way is a registered trademark of my law firm, is an irrevocable asset protection trust that starts as a domestic trust. Easy to use, simple to manage, and you can even be the trustee yourself. But here's the brilliance. Built into the trust from day one is a mechanism to trigger offshore protection when things get ugly. Let me paint the picture. You set up the trust, you're the settler, and you're also an initial trustee. Our offshore law firm, licensed and bonded, is the backup trustee. The trust includes all the legal language of an offshore infrastructure, including an offshore trustee and Cook Islands LLC, but it's passive at first. No flags to the IRS, no need for international tax filings for the trust, just simplicity and control until the storm hits. Now, domestic asset protection trust, or DAPTs, sound great on paper, but there's a fatal flaw. Case after case has shown that U.S. judges are not always bound by the state where your trust is formed. In fact, they can and often do ignore those laws entirely. Take a real case. Dr. Dahl, a California resident, set up a Nevada trust. The Nevada trust does have some strong asset protection statutes, right? Well, his wife filed for divorce in California, and the California Appeals Court ruled that since they lived in California, California law applied. The results? His wife revoked the trust. Assets exposed. And this is not just a one-off. We've seen judges say, you're here, your assets are here, so I'm taking them. So this is why we say when the lawsuit comes knocking, domestic trusts get picked apart like a tuna sandwich at a seagull convention. So how does the trigger trust avoid this fate? Let's break down what happens when you pull the trigger. When a legal threat arises, a lawsuit, divorce, creditor attack, or when your appointed protector alerts our offshore trustee, then in a matter of moments, the U.S. trustee is removed. The control shifts to our offshore trustee law firm, and the trust wording updates to remove the U.S. jurisdictional language. Assets move, if needed, to a safe international bank account beyond the reach of the U.S. court. So now this isn't automatic because that would trigger foreign trust status with the IRS prematurely. It requires human intervention, your decision or your protectors. And this is what makes it smart, legal, and IRS compliant. So why do we use the Cook Islands? Now, we also use Belize and Nevis as alternatives. Simple. They do not recognize U.S. court orders. To even bring a lawsuit there, a creditor must hire a local attorney, no contingency fee attorneys. The burden of proof? Beyond a reasonable doubt. The criminal standard. The courts won't hear a fraudulent transfer claim if the statute of limitations is passed. Now, the Cook Islands Trust protects the assets immediately. It's just that the judgment creditor has 1 to 2 years. And even if your opponent beats that clock, we've never seen the trust penetrated. So let's say it again, 1 to 2 years. After that, even if a U.S. judge screams bloody murder, the Cook Islands court just sips tea. Now, inside the trust, we place a Cook Islands LLC. You're the initial manager. You control it. You open accounts. You direct investments. And if legal pressure builds, the offshore trustee company law firm can step in, become the manager of the LLC. Why? because if they didn't, the courts would take it. They're a licensed bonded law firm. Their job's to shield your assets until danger passes. In fact, 30 years of setting up trusts in the Cook Islands, we've only seen a track record of impeccable integrity. In fact, the Cook Islands trustees are the most regulated trustees in the world. Now, for tax nerds out there, let's address the IRS side. Initially, it's a domestic trust, so no need to file the IRS forms 3520 or 3520A in the beginning. No separate tax ID needed. The trust uses your Social Security number, so no FBAR filing. FATCA doesn't apply at this stage. Only if you pull the trigger and convert it to an offshore trust do the international reporting rules kick in. And even then, these forms are simple and manageable. Now, the goal here is simplicity and stealth until you need the strength. Want to open a bank account in the name of the trust? Easy. Want to run a business that the trust owns? No problem. So we form an LLC owned by the trust. You run the LLC. You keep investing, managing properties, or trading assets. And here's a smart move that we build in. We open a small offshore account with a couple $1,000 from day one. That's your open baseball glove ready to catch your assets fast when the game turns rough. Now here's the critical question. Should you wait until trouble shows up to set this up? Spoiler alert, no. And the reason why is in the next section. Now, almost every asset protection structure is subject to a fraudulent conveyance look-back period. Now, this is where creditors try to argue, you've moved your assets just to avoid paying me. But here's the key. In the Cook Islands, the statute is as little as 1 year. In most states, 3 to 5 years. In U.S. bankruptcy court, 10 years. And here's the kicker. The clock starts ticking the day the trust is formed and funded, not the day it becomes foreign. So if you start today and fund it, even if you don't trigger it for years, you're building legal immunity. So wait until the lawsuit hits, and it's often too late, especially with divorce. So just like buying flood insurance, after the hurricane lands, no one's selling. So who's this for? If you own real estate, we have some extra tools we use for real estate. If you have assets of over $500,000, if you're a business owner, a doctor, an entrepreneur, or just a high earner, this could be for you. You're a target. Your wealth makes you a magnet for lawsuits. Now, you might not think anyone's coming for your money today, but when they do, you'll either be protected or exposed. And remember, most people want two things, protection and control, and the trust gives you both. Now, let me be direct. We've been doing this since 1991. We've helped, I believe, over 147,000 clients. We've set up more Cook Islands trusts than any firm in the world. And here's the most important part. We've never had a single client lose money with a properly structured trigger trust. This works. So it's not just theory, it's real law, real strategy, and real protection. Think this is only for lawsuit protection? Nope. The trigger trust also includes estate planning provisions, and this means when you pass, your children or heirs can benefit without probate. If your heirs face lawsuits or divorces, the trust continues to protect those assets. So therefore, you create a legacy that's not just about wealth, it's about wisdom and resilience. And as I said, we own the federally registered trademark for the term trigger trust. So if somebody else is trying to offer you a trigger trust, they're either misusing our intellectual property or giving you a watered-down knockoff. We invented this structure, we perfected it, and we're the only ones legally allowed to call it what it is. So let's go ahead and sum it up. Domestic trusts fail because judges often ignore them. Offshore trusts work, but can be complex to use full-time. The trigger trust gives you the best of both. Ease of use now and ironclad protection when you need it. So you stay in control until you need help. And then we step in to legally block the threat and protect your wealth. If you've got assets you care about, if you've been thinking, I should do something before it's too late, this is that something. We walk you through the setup, customize your needs, and give you the long-term peace of mind. Feel free to visit us at assetprotectionplanners.com or call us at 1-954-400-1050 to request your free consultation. And before you go, if this video gave you clarity or opened your eyes to smarter legal planning, click the like button and hit subscribe so you don't miss the next strategy that could save your fortune. This is The Business Guy. Stay safe, stay smart, and when legal trouble comes, pull the trigger.